since we have everyone here. Good morning, ladies and gentlemen, viewers on the RWC NAMCO Sports Arbitration Mooting Competition Facebook page. We are live on Facebook page at the moment. Thank you so much for joining us. Welcome to the first webinar for the mooting competition. Good morning, ladies and gentlemen. Good morning, Richard. Good morning, Samrith.
Morning,
Thank you so much for joining us. Together with me, actually, I have my co-moderator, Wong Ziying. Both of us will be moderating this session. Just a brief introduction. Again, this is a webinar on sports law and sports arbitration. We are organizing the first sports arbitration mooting competition in Malaysia, and I believe maybe the world, in fact, is a collaboration between NAMCO Management LLP and Richard Wee Chambers. We are delighted to host this sports arbitration mooting competition, and towards the organization of the mooting competition, we feel that we need to give a little bit of exposure on what is sports law and what is sports arbitration to assist the potential mooters to compete in the competition. So today, we have two very distinguished speakers who are practitioners in sports law and sports arbitration. Perhaps Ziying, maybe you can introduce our speakers today.
Okay, Mao. Good morning, everyone. We are honored to have two speakers for today's session. Let me briefly introduce both the speakers. Firstly, we have Ms. Samrith Kaur, currently the President of Sports Law Association Malaysia, SLAM, and the Managing Partner and Mercer Samrith Samjif Partners in Kuala Lumpur. Ms. Samrith is a certified mediator as is on the panel of Bar Council Malaysian Mediation Centre, MMC, and as arbitrator, mediator, and adjudicator on the panel of the Asian Institute of Alternative Dispute Resolution and Asian International Arbitration Centre. Next, we have Mr. Richard Wee, currently the Managing Partner and Mercer's Richard Wee Chambers. Richard graduated with a Bachelor of Law Honours from the University of London in 1996, completed the certificate in legal practice in 1998, and was admitted as an advocate and solicitor of the High Court of Malaya in 1999. Recently, the Ministry of Youth and Sports appointed Mr. Richard Wee to the advisory panel of experts. I will now begin the session with Mr. Richard. Is it okay for you?
Yeah, sure. Well, first, can I just say, number one, really nice to have Samrith on board. Hi, Samrith. Much obliged for sharing some time on this project. I know Mal and Ziying has been hounding you and chasing you for this. Thank you so much. And I heard that you prepared an extensive slide. So that goes to show the measure of your commitment to the area. Thank you so much, Samrith. Thank you.
Oh, my pleasure.
And, then, of course, I must thank NAMCO. People in NAMCO, Malaysia and her big team behind, and Ziying, both happen to be also my colleagues, but today we speak in a different capacity. Yes. Terima kasih for having me here. And I do apologize that I was a little bit late. I was on the phone with a friend, ironically on sports law, with our good friend and mentor, Dr. Jadi. So yes, I'm already just shoot. Hopefully I can answer.
Yeah. All right. Before I pass the floor to Ziying, I would like to thank both Richard and Samrith for joining us, for spending your time this morning. Right? I know it's a weekend. It's a morning on a weekend. So thank you so much again. So now, Ziying, take it away.
Okay, thank you, Mao. Okay, Richard, can you first and foremost actually to briefly let the participants and also to all the people in the Facebook where we have live to know what is about the sports law actually?
I think Samrith and I get a question all the time. Actually, the core, the pure, this is my personal opinion, and I've been giving these talks on this area for quite some time. I always, even the early days of SLAM when we were in Pro Team, we were going around the country to give free talks. I propounded the fact that sports law, the pure sports law, is only 4 areas. which is number one, sports arbitration, which is where Ms. Samrith is will be leading it later. Number two is about governance, governance of sports. For example, if you look at from football point of view, we have FIFA, AFC, FAM, and then the state football. So that's called governance, and that there are elements of law at every level. The third one is another pure sports law area is doping. Only sports have doping. Because normally when you get caught for drugs, you go to prison. But in sports, if you get caught for drugs, you get suspended and your medal is taken away. So there's a totally separate and independent jurisprudence there. WADA, the World Anti-Doping Agency, have an extensive rule of law and jurisprudence for us to study there. Some lawyers are just specialized in anti-doping, for example. The fourth one is regulations, which I further divide to two. On the field regulation and off the field regulation. So on the field, so let's say Samrith and I are playing badminton, so there are rules which govern our game on the field. Off the field is where if I turn out to be a cheat, then I pretended to be a Malaysian player when I'm actually from another country. So then disciplinary action will be taken on me, and that is regulatory off the field of play. So these are the four areas of pure sports law, but without fail, sports law overlap with many other areas. So that's why a sports law practitioner needs to know a lot of other areas. So a contract law, law of tort, a little bit of trust, a little bit of property law, because we deal with stadiums and assets, intellectual property. So, like, you know, my good friend Shu Sarguna, he's a VP of SLAM, rightly so, because he's a very good IP lawyer. He advises IP in sports, branding issues. And there's also an element of crime involved here and there. So, Zing, to answer the question, first, the pure sports law, which is 1, 2, 3, 4. Governance, integrity. Sorry, I forgot one more. Integrity. Yeah, I forgot integrity. Integrity is anti-corruption. Yeah, one more. Anti-corruption, specifically for sports. Governance, integrity, regulation, and arbitration. Then there's also doping. So, in fact, there are not 4, there are 5. Sorry, there are 5. 5 areas. Yeah, my bad. I think I still baru bangun. So, yeah, there are these 5 areas which I consider as a pure sports law area. I apologize to the listeners for the confusion. And then the other areas are the overlapping with sports. Thank you.
Well, I think that would be the unique character of sports law, I believe, yeah, Richard, because it's so peculiar to only sports. And like doping, for example, you said that if you are caught with drugs outside, it's under the penal code. But in sports, you will get suspended. So it's a two different world altogether.
Yeah,
right?
sorry, Mal, to be slightly, I'm being anal here, not
Yep.
penal code, but dangerous drugs acts.
Oh, yes.
Yeah. So because
Dangerous
luckily for me, I've had some experience. For some reason, I feel that my career accidentally falling into sports law about 8 years ago was the culmination of many years of doing a lot of funny laws. So by the time I started doing sports law in 2012, 2013, it was quite a natural evolution because I happened to know a little bit of everything. So anybody here who want to do sports law, you need to learn to do a little bit of everything: criminal law, contract law, tort law, a little bit of everything. Then sports become less cumbersome.
Right. Okay. So taking from what Richard has stated and the unique characteristic of sports law, I believe there is also some unique characters of sports arbitration, because there's a specific sports arbitration going on. So maybe Ms. Samrith, you can share what is sports arbitration.
Right. Thank you, Marsha.
Yes.
Good morning, everybody. Okay, like Richard has already explained, what sports law is actually a collection of many different types of law that not only applies to athletics, but sports that they play, but it also impacts sports industry. So sports law involves a variety of matters, including, like Richard said, law of contract, tort, agency, constitution, trademark, even sex discrimination, day-birth matters, personal injuries, and even criminal, like pointed out earlier. For those who are not sure what arbitration is, it is actually an alternative dispute resolution mechanism whereby parties agree to have their dispute settled by a third party. It's a little bit like a judge, but without strict formalities and strict rules of law and evidence, entangled it. So parties would have to submit by agreement to this alternative dispute resolution. So if your contract, your agreement has an alternative dispute resolution clause to go by way of arbitration, then you do not go to court. You resolve this dispute by way of arbitration. So what is sports arbitration, right? Since we know what sports law is and what arbitration is, sports arbitration is when there is a dispute in commercial nature or a dispute of a disciplinary nature that are resolved in accordance to the law, according to the governing law and structures and rules of that particular sport body. So that is, each federation or sport or association of a sports body will have not just rules, regulations, and procedures governing the sports, but a mechanism and provisions for resolving disputes arising within the sports. So, if you are in football, they will have their rules and regulation regarding. There will always be a dispute resolution clause there. So you follow that mechanism. That's how you go and arbitrate for that dispute itself. So in short, sports arbitration and dispute resolutions are governed by specific rules of that relevant sports federation or association.
So from that, Ms. Samrith, is there a requirement for the parties to have an arbitration clause in their agreement for them to go to CAS, for example, to go for sports arbitration?
Definitely. Without that, without their agreement referring to anything, any dispute that goes to CAS, you can't go to CAS otherwise. So yes, you do need that in your agreement, that any disputes will be resolved under CAS. CAS is Court of Arbitration for Sports in Switzerland.
All right. Okay. Azim, do you have any question for Ms. Samrith?
Yeah, Ms. Samrith, since you mentioned about there must be a binding clause to for both parties to actually go to CAS, right? So other than that, what are the differences actually between the sports arbitration and the non-sports arbitration?
What are the differences, right?
Yeah.
Okay. In sports arbitration, award rendered by CAS. That means when you go to CAS and they render they're the arbitrators, right? You choose the arbitrator. When you get the award, they are made public. Anybody can see them. Anybody, if you log on to the site, you will see all the cases there. But for non-sports arbitration matter, any other commercial matters and construction matters and all that, award rendered by the tribunal are not publicized. This is because the whole reason for having gone for arbitration is choosing this method is because of confidentiality. That's why for normal non-sports matters, we do not publicize, but I will, in a little while, I will tell you why you need to publicize or why is it made public. So that's the first difference. The second difference is timelines. In sports arbitration, you have to decide very fast. Okay, there are strict timelines, and not just during CAS normal hearing, but let's say there's a SEA Games, Olympic Games, you have another game waiting in line the next day. You have to resolve that matter. Let's say one athlete, in a sports in a team, got caught for something. He maybe hit the what do you call it, the racket too high or something like that. So this matter has to be dealt with very swiftly, very fast, sometimes even within 24 hours. We had a matter in 2017 when SEA Games were in Malaysia. We had the one and only dispute resolution that came to us was ice hockey. We had to decide within, I think, about 12 hours. We sat down and we just had to decide what was the decision, whether the player could play in the next game or not.
Wow, within 12 hours.
Within 12 hours, yes. So, whereas in a normal situation, in normal arbitration matters, timelines are mutually decided by the parties, or if there is, provided in the rules and regulation of that particular institution, you just follow that. But mostly it's parties will tell that they will need 1 month to file this, another month to file that. You don't get that in sports arbitration.
Oh, wow. All right. Okay.
Yeah. So in sports arbitration, the seat is in Lausanne, in Switzerland. You have no choice. Okay. Whereas in a normal arbitration hearings, you know, it's chosen by the parties and according to the agreement. You will say the seat where you want the seat to be in your agreement. But in cast matters, you have no choice. It is in Lausanne. Another difference is any party seeking to challenge or enforce a cast award can only do that at the Swiss Federal Tribunal pursuant to Swiss law. That's it. Whereas a non-sports arbitration matter, you know, it's binding wherever the seat of the arbitration is and where the award is from. And to enforce that, to enforce a non-sports award, it can be any parties which are signatories to the New York Convention. There are 168 states that have signed to this New York Convention. So even if you have an award that, you know, against another country, let's say New York, which is, you know, a signatory, you can actually enforce your award there, but not for cast. Cast is only, you know, it's only pursuant to Swiss law. Yeah.
All right. Okay. So just now, Ms. Samrith has mentioned interesting facts about different regulations for different associations, right? Different associations, different sports and whatnot. So let me move to Richard. In sports law, Richard, what are the regulations, rules, and regulatory bodies which are one common for all sports? And perhaps you can also explain what are the different regulatory bodies in sports.
Okay, thank you. Good question. Very difficult one. And it's a difficult one, yeah. Now, difficult because there are many layers. Number one, you must first see the sport itself. So like, let's say volleyball, every sports will govern themselves. Volleyball, netball, ice hockey, as Ms. Samrith mentioned just now, they have their own internal rules from the top to the bottom. So they will govern themselves. That's the thing about sports. So when you do sports law, if your client today is an ice hockey player, and tomorrow the player happened to be an athletic, where as Samrith mentioned about sex discrimination, and then she came to ask you whether you can help her, but the athlete claimed that she's more like a man than a woman. They have their own rules to govern. Then after that, you have tournaments which are multi-sport tournaments like Olympics, ASEAN Games, SEA Games, Commonwealth Games. So the organizer of that tournaments have their own rules. So for example, in Olympics, it is common when we discuss about, say, doping, they will work closely with anti-doping. Or for branding, for example, if the Olympic is signed a contract with a particular brand, the other brand won't be permitted to come in. So in that sense, Mal, there are some differing governing body. Whether you have your question, one of the question was whether there's one umbrella body. No. The closest I can think of is IOC, International Olympics, where they govern multi-game tournaments like the Olympics. So in the ASEAN Games we have one body. They are the Asian Games Federation. They control all the multiple sports. I think the last tournament was held in Jakarta and Palembang. So these are examples of governing and governance and the rules, regulation working together. Rules from top to bottom, where the top decide and it flows down all the way to the national federation.
Okay, that's interesting. So in terms of, let's say there's a case, right? So how do parties resolve that dispute? Like, for example, you are caught with doping. So can you just let the viewers know what would be the step?
Okay. Oh, sorry. For me or somebody?
For you.
Okay, right. Because it's arbitration, sure. Okay, yeah. All right.
So it's sports, and then we cash.
I'm going, but somebody can correct me if I'm wrong, because I think she's a far more expert than me in arbitration. Now, Now, let's give example. I hope he's not listening in. He won't sue me for defamation. But let's take example of our beloved Dato' Lee Chong Wei, a superb legendary player. And unfortunately, many years ago, during an Asian Games tournament, he was tested positive. And because he was tested during a multi-game tournament, Asian Games, so the Asian Games people actually had control over that case. So that case was heard internally, and it went back to the World Badminton Federation to decide the penalty. So it never went to WADA, or it never went to CAS. WADA, by the way, don't have a court. There's no court for WADA. WADA will discover, WADA is World Anti-Doping Agency. They do a test on you in the world tournament. They find you positive. Then they transfer the case to the organizer. The organizer then will take the necessary action against them. That is called result management. If you're doing anti-doping, that concept is called result management. Then, back to Lee Chong Wei, what happened was, at the Asian Games, he was found guilty and he was penalized. Then he appealed within the World Badminton Federation structure, and the case was heard in London, where again, unfortunately, he lost. But they accepted his explanation that it was a therapeutic use, traditional medicine, and his penalty was only for 7-8 months. And then he was back playing badminton again after that. So there's an example where internally they governed it and regulated it and heard it. But for example, Mal, if I'm going for a swimming competition, and or I'm doing bodybuilding, weightlifting, whatever, and it was found positive, then as like Ms. Samrith mentioned earlier, if the tournament rules require that any dispute goes to CAS or a certain tribunal, then it will be heard there, including the doping case. So that's why when you do sports law, I repeat this, you really need to follow your paper trail. Different association, different tournaments, different multiple tournaments have different rules. But as a lawyer, it's not too difficult because the concept, the jurisprudence, very similar. It's not too alien. I mean, it's just matter of whether you hear in Switzerland or you hear in a tribunal, but it's still a hearing. And then, so once you follow the constitution of the tournament, the rules of the tournament, and the rules of whatever dispute, you follow that, you can do the dispute resolution already.
Okay, great. Okay, so Zing?
Okay, since Richard mentioned about all the sports law and how all the sports govern how they actually resolve the disputes. So now I would like to pass the floor to Ms. Samrith to explain about what is the role of the court arbitration for sports in sports arbitration.
Ms. Samrith, you're on mute.
Sorry.
Nice.
For international sports related disputes, there are two entities. Don't forget that. There are two entities. One is the International Council for Arbitration for Sports, called ICAS, and the other one is Court of Arbitration, called CAS. So ICAS actually comes up with all these formulations, the administration, the management of CAS, so that CAS can stay as an independent institution just doing resolve management of sports related disputes. Okay, having that in mind, so your question was, what is CAS' role? The CAS is responsible for resolving disputes under three divisions. One is the Ordinary Arbitration Division, called the Ordinary Division, which functions as a court of first instance. That means that this division hears the matters for the first time. That's why it's called a court of first instance. It also hears it also has an anti-doping division, which deals with anti-doping matters, also in the first instance. And it's also authority for that. And the third division is the Appeal Arbitration Division, also known as the Appellate Division, which resolve these decisions of the federation, association, or sports-related bodies on appeal. That means, like what Richard said, you go into your own national federation, association, you go through all that mechanism. When you're not happy with that, then you come to appeal. If your agreement says CAS, you come back, you can appeal here. So this is the second layer, or you can appeal even in the first instance in CAS hearings. you then want to appeal if you're not happy with the decision. But bear in mind that dispute is submitted to CAS only, like we keep saying, only if there is an arbitration agreement between the parties which specifies that it be resolved by having the matter heard by CAS. But having said that, all disputes or disputes in relation to Olympic Games can only be submitted to CAS, since all Olympic international federations have recognized CAS as a jurisdiction.
Also, it is a requirement for the association to recognize CAS for it to have a jurisdiction. I see.
Yeah.
All right.
Yeah, for Olympic matters, everybody refers to CAS because it is, or they have already recognized it. But for other games and all that, it has to be in your agreement.
I see. All right. Okay. So taking that into consideration as well, could you just explain what would be the procedural rules in CAS if an athlete wants to take his or her action in CAS? What are the procedural rules?
Okay, the procedural rules are actually very much same as any other arbitration matters, except that they follow, there's a code of sports-related arbitration. It's called the CAS code. Everything, I'm not sure whether you will see this. If you see, am I showing this? Can you see?
Can see, yeah.
You can actually download this. All the procedures, starts from Rule 27 onwards, will tell you what to do and how to put in a case. So the code of sports related, the CAS code is actually a set of procedural rules. This is it, governing CAS procedures for settlement of sports disputes. The procedural rules relate to the seat. You will see in a way the seat is, which is in Lausanne. Language, when you say language, you have to be proficient in any one of the three. It is Spanish, English, or French. So these are the languages that are recognized in this CAS code. And how do you remove an arbitrator? Why you should remove an arbitrator? The administrative purpose and all that is all in the procedural rules. So the procedural rules of the code apply whenever the party have agreed to refer the sport-related dispute to CAS. Such reference usually arise out of the, like we said, the arbitration agreement, which consists of all that. So with regards to the law, in the context of ordinary, there are two things. One is the procedure, right? And one is the law. So the procedure is all under the CAS code. The law, if it's an ordinary arbitration, the parties are free to agree on the law applicable to the merits of the dispute. Failing such agreement, if you don't have such agreement, of course, Swiss law applies. But for the appeal process, the law is based on regulations of the body concerned by the appeal and the laws of the country, whichever country that came to you, in which body is, which that body is domiciled. So the procedures itself is governed by the CAS code.
I see. Ms. Samrith, if I can just ask one question pertaining to that, and maybe Richard can answer this as well. Both of you can answer this question. Ms. Samrith just mentioned about law of the country, right? And then earlier on in the discussion, we mentioned about rules and regulation and laws of the association governing the sports. Then what would be the difference then? Because if we go for a dispute in CAS, how do we decide which law to apply? Maybe there's some slight confusion there. Yeah.
Richard, do you want to?
I first, okay. Always ask me difficult question, terrible. Yeah, because this is a difficult question, really. Yeah. Now it requires a little bit of explanation.
The seat is always in Lausanne. If it's a CAS arbitration, the seat has to be in Lausanne. No questions about that.
Yeah, and therefore, correct me if I'm wrong, Samrith, then we have to refer to Switzerland law for interpretation purposes. Correct? Yeah. Basically, Mal, it's actually not that they apply Switzerland law. They still will look at the internal sports rule first. For example, if the doping rule require that you do not consume steroid more than 3 grams, for example. So that is still the sports law part. But in order to interpret the definition of consumption or discovery in your body, that they may refer to Switzerland law for purposes of interpretation. So that's an example. Yeah, but that's similar to normal arbitration. Even in arbitration, let's say Samrith and I enter into an agreement. She's representing Brazil and I'm representing, say, Hong Kong. But we agree to Malaysian law. But the case is heard in London, so there's a possibility that we may have to apply British interpretation to the Malaysian law, for example. Yeah.
Yeah, it's actually the rules and regulation just follow the sports rules and regulation. It's the law that follows the country's law, which is Swiss law.
Yeah.
Does that make sense?
I like
Makes sense.
I like the way sorry. Does it make sense? Yeah, because it is tough, a tough area, Mal. And that's why we have people like Samrit and team doing arbitration. It's not an easy job, Not any
Yes.
lawyer can go and do arbitration.
Yeah. So because when we were discussing about this, I was a bit confused when you said there's rules and regulations for the sports stuff, right? So for example, for volleyball, there's rules and regulation for volleyball, and then you take it to Lausanne, and then or rather maybe in terms of domestic or national level, it's in Malaysia. So then you have the law of Malaysia, and then so that's where the confusion starts, I think.
Can I give you an example? Mal, let's give a practical example, right?
Hmm.
So we have a tournament going on in Malaysia, and an athlete is found guilty. But like Ms. Samrit mentioned, in the tournament rules, if there's a dispute, they will first hear in the tribunal in that tournament. Kalau ada appeal, if they appeal to CAS. So let's say the scenario. So this athlete, let's say he bluff, he says he's from Perak, but actually he's from Selangor. So he represented the wrong state. So they took action against him. He lost in the tribunal at the tournament. Now he wants to appeal to CAS. So now the interpretation of the rule will be subjected to Swiss law. But whether this athlete's right or wrong in representing that state will follow that sports law, that tournament law. Whether how do you interpret the definition of state? Where do you come from? For example, So that's just a very simple, basic example.
Yeah.
Well,
Yeah, and just to follow on this, it's also very maybe something that you all can relate to is that in a dispute relating to football, where parties will most likely have already determined an application of FIFA rules, right, in the agreement. So therefore, in such cases, the panel, that means the arbitrator, primarily applies FIFA rules and Swiss law.
I see. Okay.
I think Mal and Z is now like.
You know what? Yeah, because people get confused with what seat is. Seat is where the
Correct.
Country is.
Yeah.
Yeah. Well, I hope the listeners, got that. I hope it's clear for the listeners, for the viewers. Okay. I would just want to take this opportunity to thank the viewers on Facebook for joining us. If you have any questions, please do put in the comment box down below. The speakers can take questions as and when, throughout this whole webinar. So please do ask questions. We want this to be as interactive as possible. Ziying, do you have any questions?
Okay, since Ms. Samri and Mr. Richard mentioned a lot on sport arbitration, so now I would like to ask Mr. Richard, is there any laws or specific acts that in Malaysia who govern sports law?
Specific act of parliament?
Yeah.
Oh, sports law, no arbitration. Your question is what governs
Yes.
sports law, right? Okay. I think the closest will be Sports Development Act, 1997. In that act, it created an agency called the Sports Commissioner, which is the policeman for sports in Malaysia. When I say policeman, I'm talking about management of association and tournaments. There's also a dispute resolution clause there. We're supposed to have under the 2018 amendment, Parliament has empowered the government to create a sports dispute committee, which I hope will be created soon. And there's also other issues about licensing and whatnot. The other act of parliament I will read will be the Merdeka Corporation Act, the Akta ISN, the National Sports Institute, the Akta Majlis Sukan Negara, the MSN, which created MSN. Then there's an act of parliament for stadium, Perbadanan Stadium Nasional, which governs our Bukit Jalil, Panasonic Stadium. There's even a government agency running stadiums in the federal government's assets. And then Let me see. Of course, there's also the Act of Parliament which govern. There's one more, Merdeka Corporation, ISN, MSN, Stadium. Uh, yeah, I think that's all I can think of at the moment. The rest are all probably, yeah, regulation or that. Yeah, sorry lah. Saturday morning, I slept late last night, work late, so it really still blur. Yeah, yeah.
No
Sorry,
worries.
sorry. Yeah, but
I think all of us are still.
yeah, maybe somebody can you correct me? Did I, is there any parliament I missed?
I can't think of anything. You probably
Yeah, I think that's more or less it, right? The ISN Act, MSN Act, MSN, of course, being the old boy, has been around for a long time. Stadium, Sports Development Act, Merdeka Corporation, which governs the Merdeka Stadium, and the stadium, the former Stadium Negara, now torn down already. Yeah, I think OCM, there's no Act of Parliament for OCM. Even anti-doping has no Act of Parliament, not yet. Yeah. Well, for the record, Mal, the anti-doping of Malaysia, right, was brought in by a treaty, a Copenhagen treaty. You read through, they accepted the international treaty, and that's why Malaysia subscribed to WADA.
I see. And is this widely subscribed by the nations in the world?
Yeah, I think, well, I wouldn't say, I think many, yeah, many. Because I think there's this international anti-doping code or something like that. And of course, the governing body is WADA, based in Canada. And they are the policemen for anti-doping. But in Malaysia, we have an anti-doping agency of Malaysia, ADAMAS. It's a good friend of mine there. A lot of my friends are there. And they police the anti-doping in Malaysia. But unfortunately, our ADAMAS is not a specific structure created by Parliament yet. It is a team under the Ministry of Youth and Sports, which is also an issue because WADA doesn't want that. WADA wants ADAMAS to be an independent body. So that's a WIP, work in progress, to get that done.
I see.
Yeah, there is a need to be independent because you can't have it falling under any agency or any ministry, you know, just to be to make sure that it's unbiased decisions that comes out.
Okay.
Totally agree. Yes, correct. Yeah.
Oh, that's great. Zin, question?
Just now you mentioned about where the court arbitration for sports CAS actually have the power to give certain awards. So my question to Ms. Samrith is, if a party is dissatisfied with the CAS award, right? Can they set aside, or what are the grounds that they can be? I mean, the awards can be set aside.
Yeah. Like any award, even CAS award, although it is binding when it's communicated to the parties, it can be challenged, but it's challenged on very limited grounds. There are about 5 grounds only that you can actually challenge the award. First is if the arbitral panel was not properly constituted. That means they did not have the right expertise, or something went wrong with the when the constituting the panel. You can either have a single arbitrator or 3. Usually they go for 3 arbitrators. So that could be one of the reason. Or if your agreement said 1 but you chose 3, but you know it was not mutually agreed, something to that effect. Secondly, the arbitral panel erroneously accepted or declined jurisdiction. So they may have just gone on a tangent of their own and declined certain jurisdictions. So if that is the case, you can challenge. Or if the arbitral panel rule on a different claim from the one submitted by the parties, or fail to decide on one or more of the claims submitted. This happens. Sometimes there's so many subdivisions, and sometimes people may miss 1 or 2. So if you think that your decision did not cover all, you can challenge the award. Or if there is any essential procedural rights that were breached, that means breach of natural justice. You did not give one party equal time to present his case, or you were shutting one party down. You were more inclined to listen to the organization, for example. If you feel that that you were biased, or it wasn't it was breach of natural justice, yes, you can then try to set it aside. Or if the award was contrary to public policy. So, it depends on your country whether you have certain laws. If it goes against the public policy, definitely then you can challenge the award. Since the seat of arbitration is located in Lausanne, the setting aside, challenging the award can only happen, can only be filed before the Swiss court under the principle of lex loci arbitrate. That means the law of the place where arbitration is to take place. And it must be done within 30 days of the party receiving the notification of the decision. So, in short, you can, but it is only on limited grounds.
Okay, I was just about to ask about the jurisdiction of the national courts, and you answered that already. Great. After I mentioned about that the viewers can ask questions, suddenly we have a few questions on Facebook. One of the question, I think this is directed to Ms. Samrith. The question is, will sports arbitration being held the same as regular arbitration? I think this one would be in terms of the number of panels, the constitution of the panels and whatnot. I think that's the question.
If you're talking about constitution of the panel, it is the same, but in arbitration, the normal arbitration, you can appoint anyone. It's party autonomy. They can go and choose whoever, unless it's stated in the agreement that is you appoint a certain arbitrator, or if the appointing authority is, let's say, AIAC or CITRAC or whatever, so you go to that body and they will appoint the arbitrator. But for past arbitrators, they have a list, a closed list. You can only appoint the arbitrator from that list. Okay, and once you are an arbitrator appointed in that list, or once you're in that list, you also cannot act as a counsel.
But is the appointment of the arbitrator appointed by CAS or by the parties from that list?
They can appoint, they can go to the list and they can choose. Unless cannot decide, then maybe the president will then appoint. Or if you have, a panel of 3, you choose, and then the two, you appoint one, the other person will appoint the main, or the authority will be, sitting authority will be appointing. But you can only choose from that list.
I see. All right. Okay. We have another question on Facebook, and maybe Richard can answer this question. The question is, can executive body of a sports association or federation impose sanction on an athlete? Will there be a separation of power between executive body and judiciary body in sports world? If I understand correctly, FIFA does have a judiciary body, specifically deals in disciplinary matter.
Yeah, thanks, Mark. In fact, I'm reading the question while you are addressing it from Wei Song. Thanks, Wei Song, for the question.
Yeah.
Generally, yes, every federation, whether it's NF or IF, NF is national federation, IF is international federation. They ought to have a separate judicial body. I've heard and read some comments of certain associations around the world where it's fused, which is actually technically incorrect. But in Malaysia, I can say safely that almost every association that I have come across, they have a separate judicial body. So in the Wei Song's example of FIFA, the same applies in FAM. FAM has a very strong disciplinary committee, and they have their own judicial body where the matter can be appealed within the football association. So yes, it should be separated, and most of the time it is.
Okay, great. I have one question to Richard. For sports law, right, Richard?
Yes.
This may be a basic question, right? But who should be aware of sports law? Like, who are the parties who should know and understand sports law in depth?
I see. Well, law. Well, if you put it that way, then it's actually the rules and laws and regulation of sports lah. Who should know? I mean, other than the 4 of us who are lawyers, then I think people who are maybe team managers, they need to understand the rules and regulation, anti-doping, for example, selection process, the visa application to go overseas, take part in the tournament rules, what are the requirements of tournament rules, blah, blah, blah. So the team managers, maybe the office bearers of the association, they should know. And the team coach definitely must know it's some basic rules and regulation. Then I know some association have their own legal advisors who may be a lawyer. Some of them are by practice because they've been doing it for many, many years. Even though they're not lawyers, they understand the rules very well. Some of the esports team, for example, I know they engage contractual advisors who are not necessarily lawyers, but they understand how contract works, for example. So, of course, the other area people is the media, because the media have to write articles and reports. I think most of the media, the journalists, they know some basic rules and regulations. I remembered last year when one of the football players from Pahang refused to return to Pahang and wanted to play in Thailand. And the journalists understood the FIFA and FAM rules when they post questions. So that's an example of knowledge on sports. I suppose athletes themselves, the athletes must know some things, don't simply consume steroid, for example. I suppose even parents whose children are involved in sports, they should know some basic sports rules, sports regulation. Of course, tournament organizers, I forgot about them. The people who create the tournament, they definitely need to know that. Quite a lot of people, I don't think I can cover all. Maybe if I miss anything, maybe Samrith can add on. Or maybe I was inaccurate in the categorization of the people involved. But I think generally is that lah.
Yeah, Ms. Samrith, any additions to that list?
No, I agree with. I think he's covered almost everything. He even put in parents there, which yes, parents also have to be, they have to know the rules and regulation of the sports their children are playing. Yeah.
Okay, all right. We have one more question on Facebook, by Hao Yan Ching. Does the word shall and may bring different effect on an arbitration clause, which it will render the clause not absolute?
This one must ask Samrith, huh?
Samrith? Yeah.
I think all the lawyers will know this. Shall has a very definite definition. Shall means you have to. May is either you want or you don't want, in simple terms. So yeah, if you have any provision that says shall, you must follow it to the T. That's my simple answer.
Okay.
Yeah. So basically there's shall, I would say, is a mandatory, and may is you can or you choose either to like evade away. But okay, so Ms. Samrith, just now you also mentioned about the list of arbitrators that can sit on the case.
Mm-hmm.
Okay, so what is the qualification, or who actually can be a sports arbitrator actually?
Okay, CAS has some requirements that you have to have good knowledge and all that. So to be a sports arbitrator, you need to have appropriate legal training at least, competent with sports law and or international arbitration, because CAS only does international, right? You must have good knowledge of the sports in general, whichever sports, and a good command of at least one of the CAS language, working language, that is either French, English, or what did I say? Spanish. So these are the things that you have to be if you want to be in the list. But however, the CAS arbitrators and mediators, like I said, if you're in the list, then you cannot act as a counsel. Okay. And how you can improve yourself is that whoever wants to be a sports arbitrator, go for training. AIAC came up with sports arbitration certification that Richard and I think took some years back. I hope they're having it this year. Look out for that and go for the training, because that gives you a very wide perspective of what sports arbitration is, what doping is, and gives you really a good insight of how it works. So if you're passionate in sports matters, sports arbitration, you know the rules, the regulations, and all that, there's no stopping you from being a sports lawyer.
On that note, maybe both of you can share your experience being sports lawyer in Malaysia.
Richard will have plans of
Whoever can start.
Sorry?
stories. I will give you until tomorrow.
I'm going to try and cut it down to 2 minutes. Yeah. Well, thank you for the question, Ma. I think for people like Samrith and I, doing sports is I will first dare to. I know I speak for me, but I dare to say that for Samrith is because we both like sports. You need to like this area in order to do it. And for me, in terms of experience, it is fascinating to see the combination of so many areas of law coming together. And for me, I've always loved sports since I was a boy. I think share the secret with all of you. I actually wanted to be a football player when I was a young boy, but I was a horrible football player. So then my first ambition was to be a sports journalist. That didn't work out. I ended up becoming a lawyer instead. So for many years, I labored doing affidavits and contracts and whatever, until about 10 years ago, I stumbled upon sports law with my colleagues. And then since then, getting to meet some of the national athletes, some of the walking into the stadium to do your work, dealing with the people and handling anti-doping, sorting out branding for sports, which everybody's talking about it, but they don't realize that we are the lawyers who did the work. It's fascinating, and it's nice to contribute to the country, and of course earn some fees along the way. It's nice to also earn a living doing the work. Very rare can we as a lawyer say that we love what we do, but I definitely love what I do. And if I have my way, I would like to just do only sports law. But I think Marlisa, being my business partner, will know that's impossible nowadays. But it's nice. I enjoy doing it. I enjoy doing the work. Much obliged.
Samrith?
Yeah, I too. Yeah, I think I echo what Richard said. I think you have to have a passion in sports. You need to know that you are making a difference. I can share the same story as Richard. Not that I wanted to be a football player, but my brother wanted to be a football player. And my dad told him, that ain't going to get you no way. And until today, he still takes a tip with my father, because he said, I could have been making more money as a football player. But there you go, But yeah, we do a lot of background work. We're not out there with the athletics and all that, but we do their agreements. We look into the sponsorship agreement. My start of developing all this coming to sports law was when my firm was doing a lot of matters for Sepang Circuit. So we were the in-house lawyers, drafting everything, trying to, whenever they used to change any, whatever they needed to do, marketing, sponsorship, and all that, the licensing right, the broadcasting right, we took part in all that. So that actually created the interest. And then going for the sports certification in AIAC also broadened my thought of saying, wow, this is a different world altogether, and very interesting and exciting. So I would encourage any of the students, pick up the call AIAC. They usually have it in September, right?
Yeah, I think so. September, during the sports month. Yeah.
Last year they didn't have it because of COVID. So let's hope they will have another one, and everybody can join in, whoever interested. That is a good starting point, I would say. And that's all. And if I may speak, if you don't mind, a little bit on what sports, because I come from Sports Law Association Malaysia. Richard is one of the members, as we are founding members. I just want to say very briefly that because all of you are students here, anyone who has interest in sports and want to do something, want to get involved, please join this SLAM. It's called Sports Law Association in Malaysia. It was formed in 2016 with the purpose of having professional body to promote ethical and professional standard of conduct of sports law practitioners in Malaysia, including promoting education of sports law and resolving this sports. So what today's webinar was on sports law and resolving as an arbitrator. So, join us. This was one of the things that, was in mind when SLAM was formed. So the objective of SLAM is actually just to advance the interest and develop of sports law. The idea to bring together athletics, sports administrators, lawyers, government bodies, and sports associations alike to navigate the complexities of sports law and sports disputes. SLAM's vision is actually to establish a professional body that will be utilized by and complement sports law practitioners and other professional players as communication and education platform in order to inform or discuss or dialogue with the sports law in Malaysia. So we are looking into developing sports law. We are looking into publishing our own journals, which you students can contribute to. And we will be organizing sports conference later this year, and we'll be having seminars and workshops and webinars in the coming months. So do join us. Look for it. I think we are in. You can look us up look us up in LinkedIn. I think in Facebook. And for the younger one in Twitter and Instagram, which I have no clue how to get on to. But yeah, do look us up.
Okay, all right. Well, just a clarification, Ms. Samrith. Who can become a member of SLAM?
Anyone, a student, even a foreigner. So it can be, whoever is interested in sports. You can be a student. If you're a foreigner in this country and you want to be a member, you can be.
Okay, all right. Well, time has flown by very, very fast. It's almost 12 p.m. But we have one more question from the viewer on Facebook. Perhaps Zine can have a read.
So the question is by, I think, Julian. He asked about what happened if there isn't a fair hearing before the national or the international federation IF before appealing to the court arbitrations for sports. So does this mean that the parties has not yet exhausted all the legal remedies that are available? Perhaps both Samrith and Mr. Richard can also address this question.
Yeah, surely. If he is just in the federal court level, that means he's still in the first instance matter. He still have a bite to the secretary if he wants to appeal. He can.
Okay, I see.
But in fact, Samrith, I don't know. I totally agree with what you just said. I subscribe to that view. But I think this question wants to know whether, let's say, somebody is upset over something happening in a local tribunal, and of course, the person lost, and the person want to go upstairs to CAS. Can the person go sideways to KL High Court and ask for a judicial review before appealing to CAS?
I don't see that.
I think they have to appeal first. Yeah.
And also you must see the agreement. What does the agreement say? What is the dispute resolution agreement in the clause? Because if it doesn't provide for to go to court, you can't. If it says only arbitration or whatever way, you have to follow the status. So whichever federation, whichever sports regulation, you have to see what is the mechanism there. If there is a challenge or appealing mechanism, you have to follow that.
Okay. All right. So before we end the session, I have one more question to both speakers. In the event, let's say an athlete was caught for doping, and then he went through all the procedures, right, until CAS. And then at CAS, he wasn't found guilty. He was basically wasn't found guilty. But in the meantime, right, his endorsement, his sponsorship all went away. Because at first he was found guilty and then at CAS not guilty. What can that athlete do? What would be his remedy for that? What can the athlete do in terms of his sponsorship, deals, endorsements and whatnot?
Somebody want to try first?
Oh God, this is tough one.
Yeah, it is a tough one.
So
Asking all the tough questions.
this will be loss of income, right? So actually, it's not. I think you can't answer yes or no what he can do. It all falls back to the facts of the case. Was he wrongly, was he wrongly accused from day one? Was there malice involved? Or was there something that was, there was a suspicion? So all this had to be weighed, and then again, who is he going to sue? Who was the body that took him? Who faulted this?
Mm.
Can he sue the body? Maybe he can, but what will he get? Then all this evidence have to come through. So there's not I think, a straightforward answer to this. A lot of things we have to look at, especially to the detailed facts of the case.
Okay. Richard, anything to add?
No, I subscribe to the view. If I can just maybe add a layer to that, is that if you do actually sue anybody, which is like, who can you sue, right? Then maybe the only person you can sue is the anti-doping agency, because you're alleging that the anti-doping agency didn't do a proper test. That's a dangerous area to go in, huh? Very dangerous.
That who brought him there, somebody in his association or whatever.
Yeah. And then and that is a risk you take when you take part in sports. And the fact remains is, at the first instance, the test came in specifically for your example, Amal. The test did came in positive. So, and this is a laboratory. This is not some man-made test, And usually there's a sample B. If sample B is also positive, so then and later on the athlete is found not guilty for some technical reason, for whatever reason, you cannot blame the association and the anti-doping for finding you guilty. And so then it's really up to you as an athlete to negotiate with your sponsors on to hold on. Like what happened to Tiger Woods, many of his sponsors hung on during his his funny incident about 10-15 years ago when he was caught cheating on a wife, for example. Allegedly, no more alleged, it's not proven. Example lah, So yeah, but good question, Mal. It'd be very interesting if the athlete want to sue. I would like to see what the lawyer do, and what area of law the lawyer go under with, under at,
Because it's all very technical, like Richard was saying that there's sample A, sample B, everything is very technical. So if you fall into that sample, you are not, you are just doing your job. You have to, actually suspend him or whatever it is. So later on, if there's another sample, another test that if he's not, so it's nobody's fault, if you think about it technically, because they just went through by the rules. They found him, the substance was there, and later on maybe the higher test or whatever, it wasn't there. So yeah, quite difficult.
A good question, Mal. For the record, there have been some cases of athletes who tested positive, then yada, in the end found not guilty, but appeal allowed. Not guilty, the appeal was allowed.
Yeah.
So
correct.
Then flowing from the decision of the appeal being allowed, the athlete either is can go back to participating or whatever, So then yes, there's a possibility the athlete may want to sue for loss of income and all that, but it will be very tough. Very, very tough. Like what will Samrith say?
I can imagine.
Yeah, the WADA people, they're just doing the job. They cannot be sued for that. Yeah.
Well, thank you so much for answering that question. I think Ziying has another question as well. Ziying?
Okay, so both of the speakers, since already 6:12, so we will wrap up this by having two speakers to just sum up or give a piece of advice to the students who actually want to pursue or also pursue a career of sports law or sports arbitration? Yeah, to wrap up the whole sessions today.
Can I invite ladies first, Miss Samrith, to go ahead first? Yeah.
Thanks. Okay, all of you who are students and who would want to go into sports arbitration or be a sports lawyer, there's no stopping you. Make sure you have a passion for it. With passion comes everything. You will want to know the rules, you will want to know the game. You need to be in the field to know what actually is going on. You have that passion, you can't go wrong. And you know what? If this is your passion and you're practicing sports arbitration or sports law, I mean, you got it made. You don't have to worry about anything. You're actually doing what you love. So good luck to all of you. I hope you stay on and look into this area of this prestige area. Thank you very much for having me.
Thank you, Ms. Samrith. Richard?
Yeah, thanks, Samrith. Yeah, well said. I think she said everything that I wanted to say. But can I just promote the sports arbitration moot competition? For a long while, I have personally seen this the need for doing this, and my style is, don't trouble people. Instead of asking people to organize it, I'll just do it myself, lah. So then I'm very honored and very fortunate that of all the business partners I have Marlisa as my partner, who is the so-called CEO of NAMCO. I've seen NAMCO grow many years and organizing quality mooting competition for novice arbitration. So when I approach Mal, who literally sits in next room in the office, and she agreed to do this with RWC. And I encourage all law students to take part in the moot competition, because it's actually a good start. It's where you learn. And the question that was drafted is drafted by the legendary Dr. Jadi from UKM. He's one of the best, if not the best, sports law professors in town. And he drafted this question. It's not an easy question to draft it, but he did it. And I want the students to try and test themselves this question based on what Ms. Samrith and I has shared with you. In terms of a career, I adopt everything that is mentioned by Ms. Samrith. I think it's a wonderful career to go in. Not often can you meet your superstars and call them your client. So yeah, good luck to everybody, and thank you Mal and Zing for organizing this. Thank you NAMCO for working with RWC. Thank you Slam, Ms. Samrith, for coming in to do this. I was the one who told Mal we must invite Ms. Samrith, because Slam is the body that we all look towards to. I should know, I created the Slam, so we must invite you. In fact, Samrith, later on, I hope to have you as one of the judges at the arbitration. I'll call you on the point.
Sure.
You must come in, huh? Yeah. Okay.
Yeah.
All right. Thank you very much, Mal. All yours. Thank you very much.
Yeah. Thank you very much to Ms. Samrith and to Richard for joining us and for sharing your knowledge, your experience with the viewers. Thank you so much. Thank you to the viewers, students, academicians, legal practitioners, whoever, and to those who asked questions. Thank you so much. I do hope to see a lot of participation for the first RWC NAMCO Sports Arbitration Mooting Competition. It will be held in June 2021. So please, the timeline, the moot problem, moot abstract, everything have already been posted on our website. Please follow the Facebook page, RWC NAMCO Sports Arbitration Mooting Competition 2021 Facebook page. We are also on Instagram at NAMCO Moots. So please follow us on Instagram as well. And yeah, I do hope to see everyone at the mooting competition. In the meantime, and towards the date of the mooting competition, we do have a series of webinars talking about sports law. So if you want to learn more, please do join us for all webinars and of course the mooting competition. Thank you again to both speakers. Thank you, Zing, for becoming my co-moderator, and thank you to the viewers. Thank you so much, everyone. Have a good day. Stay safe always. Thank you.
Thanks, Masha. Masha, just in case you want to share my slides later, you can do so, no problem.
Okay, great. That's great. So in terms of the slides, we will publish it on our website. Okay, everyone. Thank you so much. If you need to know more, follow our Facebook page and website. Thank you. Bye.
all the viewers.